Good afternoon. My name is Lou Norvell. I'm an assistant city attorney with the city of Tallahassee. I'm defending the city in a lawsuit that has been filed by Erwin Jackson. This is a case that Mr. Jackson filed last December. The case is currently pending in the county court of Leon County in the small claims division. And when you boil it down, this is a case about a locked gate. This is a gate to a power line corridor. Mr. Jackson claims that he has the right to travel along the city power line corridor to get to the back of a rental property. The power line corridor is a couple of blocks off of Jackson Bluff Road. You can see it's there to the southwest of the stadium. The corridor is highlighted in yellow. These are high transmission power lines that run through the corridor. In this part that's at issue, the corridor runs between Mayhew Street, or actually crosses Mayhew Street, crosses both to the east and to the west. The arrow here points to the location where the corridor crosses Mayhew Street on the west end. This arrow points to Mr. Jackson's rental property, and we're going to take a look at several pictures of the rental property further on. This is the rental property that sits at the front of the lot. It fronts Airport Drive. There are tenants that live there. Mr. Jackson actually owns a number of rental properties in this area, with, I believe, a dozen or more that are in this section of Airport Drive. The sign in the front is one of Mr. Jackson's rental signs. This is the storage compound that Mr. Jackson has constructed behind the residence. Back in January of last year, the electric department received a complaint that there were unauthorized trucks driving through the power line corridor. Electric looked at the Geographic Information System, or GIS maps, which are derived from the property appraiser's records, and the GIS maps indicated that the city owned the land where the power lines are located. An electric department employee then went out and overlocked the gate. Mr. Jackson then complained that he had been locked out and that he had a right to travel along the power line corridor. Mr. Jackson does not own the property where the power lines are located. There isn't anything in the property records that indicate that Mr. Jackson has any right of access to travel along these power lines.
Continue on. You can't hear?
He's on the agenda, sir.
He's on the agenda. No, he's on our staff. This is an agenda item.
I see, sir.
Okay.
Now, in this case, Mr. Jackson, from what I understand, he claims that he has accessed this property for such a long time that he is entitled to continued access. After Mr. Jackson claimed that he was locked out, there were discussions with Mr. Jackson about the city granting him an easement or actually giving him access rights along the power line corridor. City real estate got involved and ordered a title search, and the title search actually came back. The GIS maps were wrong. The city actually has an easement or the right to maintain the power lines, but does not have outright ownership of the property. This is a case where the power lines were installed more than 60 years ago, so they have been there for a very long time. Actual ownership of the power line corridor split between some private owners, and since you can't really use the property for anything with the power lines, there hasn't been any real owner involvement for years. And according to the title search, the bulk of the property in the power line corridor was owned by Mr. Atkinson, who is now deceased. In theory, the title to the property would have passed to Mr. Atkinson's heirs, but again, you can't really do anything with the property other than have the power lines there. And so since the city did not own the property, the city could not give Mr. Jackson an easement. So what happened is the electric department went back, restored the gate to its original condition, and what we have is there's a chain on the gate, and there's a city lock that gives the city access, and there's another lock which I believe Mr. Jackson says that he has a key to. Now, as you know, this issue, or Mr. Jackson came to the commission and complained about the gate. There was correspondence with the manager's office, and Mr. Jackson was asked to send documents that would support any claim for losses that he may have suffered because the gate was locked. And at that time, Mr. Jackson corresponded with the manager, although the manager had very little information about this, and we now know a lot more about the case. Mr. Jackson ultimately sent a handwritten note claiming $2,000 in rental expenses payable to one of Mr. Jackson's companies and a lawyer bill for $500. The electric manager responded to Mr. Jackson stating that the rental fees were unsubstantiated and that the lawyer bill did not appear to be related to the access issue. The electric manager sent Mr. Jackson a check for $75. Mr. Jackson demanded more money, and he filed his lawsuit. The $75 check was also sent to Mr. Jackson before the city attorney's office got involved. It is the city attorney's position that Mr. Jackson is not entitled to any recovery from the city in this case, and that in any event he would not be entitled to recover his lawyer bills relating to this gate. And we'll talk about each one of Mr. Jackson's claims individually. I have been handling the city's county court cases, and this case was assigned to me to defend. As an initial issue, Mr. Jackson, in his first filing, named the mayor, the manager, as well as other city officials in their individual capacities as defendants. The court granted a motion to dismiss the individual city officials, and Mr. Jackson has asked the court to substitute the city as a defendant. Now, again, let me be clear that all issues in Mr. Jackson's case are disputed. While Mr. Jackson is telling the media that the only issue is how much the city is going to pay him, all of the issues are disputed. We dispute his claim that he had any right of access. We dispute his claim that he is entitled to the use of this back lot of this residential property for his business purposes. And even assuming that he would be entitled to any recovery, we dispute that he is entitled to recover $5,000 in this case. Now, one of the first issues, as I mentioned, is the right of access, if any, along the power line corridor. He doesn't have any property interest in the corridor. He doesn't have any document that would grant him a right of access. So when this issue initially came up, the question was, well, why do you have any access back here? Mr. Jackson told, at this time it was Electric, that he had access because there was a neighborhood crime watch that would use the utility easement to patrol the neighborhood. So Electric goes to the police department and says, is there a neighborhood crime watch that uses this power line corridor to patrol the neighborhood? And the police department comes back and says, there is no established neighborhood crime watch in this area, and we're not aware of any kind of community patrol that would be using this power line corridor to patrol. So the evidence we have just starting out is that he's not using this, or has not been using it, for some kind of community crime watch. Now, Mr. Jackson has also claimed, well, I've been using this for such a long time that after you use it for long enough, for 20 years, then you have a property interest that gives you the right to go back here. We've got here shown on the screen, this is a current aerial just off of Google. You can see his compound in the back. This is his 28-foot storage building, his gravel yard, his fenced compound that we know that he built just about a year ago.
Is this an update, or is the attorney trying the case here now?
As long as I take equal response, I'm going to be fine.
Now, we know if we go back just 2 years, this is a aerial photo of the same aerial photo of the same area. You can see the wooded lot in the middle is the property that is at issue in this case, and you can see how densely wooded it is. You can see to your left is Atkimeyer, you can see to your right is Airport, and I will switch back. You can see Atkimeyer to your left, you can see Airport to your right. This is a picture that was taken in the backyard of the property in the fall of 2010. This was given to me by one of the current tenants at the property. And you can see how densely wooded the lot is and that there was no access through the back of this lot to the power line corridor. If you look closely and you look above the hammock, you can actually see the power pole with the power lines in the background. So based on the photographic evidence...
I mean, for my purposes, I got the gist of it here. So I don't, you know, I am kind of questioning about what are we trying the case in front of the city commission.
Yeah,
I think I understand where we are. So if there's other unrelated stuff, otherwise, if we could wrap it up.
I would agree. Go ahead. Anything else that...
Well, the issue has come up as to why I requested an investigator in this case. And if I would like to address that, if you can hear me on that. This is a property that is zoned R2. It's a residential property. This is the compound that Mr. Jackson has built in the back. It's a 28-foot storage building. It's a gravel yard. He's storing a lot of equipment back there. You can see these open trailers, concrete mixer, wheelbarrows. He has a number of extension ladders that are behind the building. The metal sign is for Jackson Properties. Here you can see the residence in the front. Property is R2. We know that for R2, permitted principal use is a single family dwelling. He's entitled to an accessory structure, but the structure has to be on the same lot and of a nature customarily incidental and subordinate to the principal use or structure. Okay, we've got a situation here where the evidence indicates to us that Mr. Jackson has residential tenants in the front. He is using this storage compound in the back for his business purposes for a separate business. The tenants don't even have any use or access of this storage building, and we've got evidence that he's got employees that are going out of this storage compound on a daily or near daily basis, serving his multi-unit apartment complexes and other properties.
What we really want to know is why you
Yeah, Mr. Burrell.
thought you had to hire
Go to just specifically
the
why you hired
investigator.
an investigator and what they were supposed to do.
And
Okay. I hired the investigator in this case, and I hired Donna Brown. She's a retired police officer. She is individually licensed. She's with a company that is licensed. She's done work for a number of local law firms. She's done work for the city in other cases. I called Donna Brown and asked her if she would just observe the property and take photographs of the property. And I can show you what she did here.
who directed you to hire the investigator?
No one directed me to hire the investigator. As a lawyer defending the case, I asked to hire the investigator.
Did anybody on this commission direct you to hire an investigator?
No.
Was anybody on this commission aware that you hired an investigator?
No.
Did the city attorney ask you to do that?
No, the city attorney did not ask me to hire the investigator. So, Ms. Brown,
I think are we ready for us to have the conversation we're going to have? I think we've seen everything we probably need to see.
I'm sorry, I didn't hear you, Commissioner.
For fairness, I'm
There is order.
Correct. This is not fair.
Well,
The other stuff I told you about is fair either, so go right ahead.
right. No, Mr. Jackson, I just polled.
5 minutes.
Mr. Jackson, just hold up,
Thank you, sir.
please.
He's a young
Mr. Jackson, just hold up. Please. I just polled the commission, and they said your 5 minutes should be granted. Would you please come forward?
It's always nice just to have a little bit of facts in here. The property that I bought, it was 60 years ago, which is about 60 years old. We had a terrible crime problem. We had people driving down an open easement there. They were breaking into our houses 20 years ago, and I did get with the police department. I met with them. There was a crime watch group. We got together in the city of Tallahassee at my request primarily, and other neighbors said, let's block this off because these houses are getting robbed on a weekly basis. So to protect our neighborhood, we did get there, and the police agreed with me. We have a lock for them and a lock for the neighbors. Okay? I have a young lady, an older lady. She's about 80. She bought her house new, living there 60 years ago. She was told, I was told, that you can use that back utility, that back green space. The developer said we could use the green space because we bought property. We could do anything we wanted back there, play with the kids, have grandkids, go ahead and do the garden, etc. Okay? That's what the owner told us. The city manager came in, and based on the power person, whoever, decides we're not going to allow Mr. Jackson to have access. She then says it took 5 months for this city to figure out they didn't own the property. Okay, the only thing I asked for, and I told Rick Fernandez, just give me back the lock. Someone's up here, I just lost an election, someone wants to play around with me. Fine, they won, I lost, take my lock. But you're not going to keep it. Give me my lock back, please. He said, no. He's been told by his supervisors upstairs that we're not going to give you possession of this. Ask Rick, he'll be glad to tell you. The city manager stated very clearly, she said, I do regret that this error has occurred. Her error, not mine. It is a case, and it caused you unnecessary inconvenience, and I apologize. The judge, this gentleman made another error. The Judge Aiken in our pre-hearing came out and said to the attorney, well, gentlemen, the only issue that we have to discuss is how much money are you going to pay Mr. Jackson? She's admitted fault. You folks have given me a check, but someone wants to play around with me and go right ahead. Mr. Mayor, your attorney says he gets paid $700 an hour. Mr. Mustian said he won't work for $200 or $300 an hour a few weeks ago, and you give me a check for my legal services for $75, and you're saying you're not jacking my chain? Jerking my chain? Absolutely you are. It goes on, and I'm not opposed to this game you guys want to play with me, and I don't believe it's the entire commission. I do believe it's the mayor, and I do believe it's Jim English, and I think we'll be able to show that. The other thing I would go ahead and say that I will continue to speak about the corruption, the self-serving, the self-dealing that's going on. And I'm going to come back here and hopefully with some of the folks out here, and we're going to demand an ethics reform package that our elected officials that we'll put together, and we're going to ask you to sign. Now go right ahead. I'm not going to take up any more time. This has been a fun experience for everybody, and I'll be glad to defend myself. We'll see you in court. I'm also going to add a few charges to that, I might say. Oh, and in summary, the very last thing I want to say is what my attorney gave me. He's always nice. I do talk with attorneys on occasion. He says that Jim English and John Marks have acted a malicious and overzealous attack on me, resulting in the unlawful taking of adverse possession of my property. The mayor and this commission are guilty, in particular the mayor and the city attorney, I hate to include everyone else, but they say I have to, are guilty of attempted entrapment, harassment, discrimination, and the willful, targeted, and selective prosecution of me. Thank you so much.
I've been told not to respond, and I won't at this point in time. Anybody got any comments on either the presentation by the staff person or Mr. Jackson? Anybody? Yes, Commissioner.
I have a comment. Really, my big concern here was the particular company that was involved, and I understand that the city attorney's office hired Donna Brown, but I would like some reassurance that we have that we put some sort of vetting process into place about the partners of the people that we hire to do work like this. I mean, given the fact, let me make clear, I see this question mark on Mr. Norvell's face, and I'm going on what I read in the paper that this company was owned by this person whose picture was up here for quite a while, and that he certainly isn't anybody that I want to be associated with or hire or pay or anything like that. So if I would hope that you all would put into effect some sort of process to make sure that we don't hire people like that again.
We can do that.
Anything else?
Well, I did have another question too, as a matter of fact. I like probably everybody else in Tallahassee was pretty stepped back, literally, when I saw that $300,000 figure this morning. And during the day, I've had to ask, where did this money go? And it turns out that that 300,000 of it was to a single company who's basically protects the city residents. We can't be an ATM machine for anybody that wants to walk, it's easy, they're not going to defend themselves, they're just going to pay you, and so on. And so I had to that was my reaction as I was getting ready to come down here this morning, thinking, well, what do we do? I mean, do we spend this money on private investigators, or do we just pay right up every time, which isn't right? I don't feel, it's not my money, it's your money, basically. So I want some clarification as to what do you mean that most of this goes somewhere? How much did we actually spend on PIs and so on?
Commissioner Ziffer?
Sure. This is crazy.
I think Mr. Cook can
I can
address
respond to
that
Commissioner
issue.
Miller's question if you'd like, or if you...
Sure, go ahead.
There's a distinction, I think, that needs to be made in terms of the $397,000 that you and others read in the paper. That was provided, and that amount is accurate in response to a request for amounts paid for investigative services. And that investigative services term really is broader than private investigators. And in response, in an attempt to provide full information to a public records request, as we try to do, we provided all payments made under the category investigative services. The bulk of that money, $300,000 plus, went to, as Commissioner Miller indicated, a provider who provides our claims adjustment services, so that when we have claims against the city for everything from workers' compensation to vehicular accidents involving city vehicles, that provider is the claims adjuster and provides services in that regard. That's provided under a contract that's titled Claims Investigative Services, so clearly identified as claims or as investigative. The balance, less than $80,000, is to investigators, which would include private investigators of this sort, but also, even in a workers' compensation case, the York, who provides the primary service, does not do any surveillance at all. If we had a workers' compensation case where we needed to make sure that an individual with a claim of a back injury on the job has a side job as a roofer, we would need to investigate that, so that that $397,000 is not private investigators of the sort that might be assumed, but just in looking at this one instance.
Commissioner Mustian?
I was going to say a little more.
Oh, I'm sorry. Commissioner Ziffer. You're right. Sorry about that.
This thing has been elevated to a place that is really inappropriate. Of all the things going on in this community, in this city, and in this county and in this state and this country, this thing has become far greater than what the issue is. And the issue is, and I'm going to remove what's happened over the last couple of weeks, is a mistake was made. There are two parts. Our part. I'm going to deal with our part. A mistake was made. It took a while to rectify. We admitted fault. We've asked for receipts. We're more than happy to pay for these. We should pay the man when receipts are provided and move on. Because this is, excuse me, I want to say one more thing. Wait a minute. And I would appreciate it. There is a certain degree of decorum that we require inside this room. And I would appreciate it, and we've done pretty well, but let's not get out of hand. Now, the flip side is, boy, I really like dealing in facts. And there is a lot of misrepresentation going on. So I'm going to ask our city attorney one quick question, because I see Stephanie Jackson and your son here. Are we following these people?
Absolutely not.
So I'd like to keep with the facts, because I got to tell you, that's really creepy when we start talking about following people. Okay, decorum. This has gotten elevated, in my opinion, and others may disagree, to a point where we need to deal with this and move on. The facts are important. A mistake was made. We've admitted that. We'd like to rectify it. On the other hand, these pictures are really disturbing. They are disturbing to me. I hadn't seen them before, but they're disturbing to me. I think, quite frankly, Dr. Jackson, you need to come to terms with what happened there. But this is a simple code violation that has become probably the biggest legal matter that this city has faced in quite some time, and it's not. And this bothers me that it's been elevated to this point. So I would like to solve this problem as quickly as we can and move on.
Commissioner Mustin.
Well, I mean, just a couple of thoughts. I mean, one is that, I always find it useful to substitute the word taxpayers for city. When you sue the city, okay, you sue the taxpayers, and we defend it. And we take what measures that we need to do, and we have, a risk management lady that is a tough lady, and she will, and which we should have. I think that's what we want. So I'm not as offended about that, that we hire investigators periodically. I mean, I think that's probably, people try and scam us sometimes. But in this particular instance, a couple of things. When somebody is a critic of the city, and there are people out there, I think we owe it as kind of a matter of fairness and perception to be extremely careful that we're being straight up and not giving the appearance of going after somebody. And I don't think we've done that here. And I would agree. I mean, I would think that I could, that we ought to be able to settle this pretty quickly and be done with it. And the compound, I'll leave it to the code enforcement people on that. I'm not sure I'd want to live next door to the compound either, but we'll, and the last thing is, and I appreciate the good work and legal ability of the assistant city attorney, but I don't really, I mean, it puts us in an awkward position to have something like this where it's like we're presenting evidence and the other side really doesn't have a chance, and we're kind of, what are we doing here? So I understand, wanting to explain what we've done, but I don't really want to do this structure again, if we can help it. So,
Commissioner Gillum.
Yeah. So I want to join my colleagues in expressing my, I think, significant disappointment that we took this situation to this level. I don't have a problem with us hiring private investigators to defend taxpayers against fraud in the system, to make sure that we don't lose money, taxpayer money, unnecessarily. I am most disappointed about this because Mr. Jackson has cost the taxpayers of this city thousands of dollars in his previous claims that we have done something unethical. We've had to hire lawyers. We've had to defend ourselves. We had to defend our integrity. We've had to go down to the Ethics Commission. And again, all to yield no findings whatsoever against any one of us up here to date, or in the history of this commission, a complaint being yielded that's been validated by the Ethics Commission. Not one. But we paid, the taxpayers have paid for this gentleman's grievances, be they political motivated or otherwise. So my biggest disappointment is that we actually took taxpayer dollars, thousands of taxpayer dollars possibly, in this situation, again, at the expense that Mr. Jackson has caused the taxpayers. And that's without regard to who you hired and the credentials of them. I think all of that deserves a second look. But the facts of this situation are that Mr. Jackson erected a structure that he is using for his business purposes on a easement that does not belong to him. I mean, I keep hearing this repeated, this is my property. You had your time, I'll have mine. This repeated, this is my property, and it is not. So we have an obligation to represent the citizens in that regard, and I get that. But to incur expenses over $4,000 possibly, or whatever the number may end up being, again, for someone who is repeatedly taxing the citizens because of his grievances that have again not yielded findings on his targets, I think is highly questionable. And I would advise that we not do that again. In fact, I would almost go as far as to say, if there are issues involving particularly this person, that it be brought to the public's attention before this commission so that it can be dealt with in that way. And I'm only suggesting that because of the history that is involved here. If we've got to sit on this end and be accused of following somebody's family, of following them personally, that's not a cross I'm willing to bear. I didn't have a decision-making process, and I'm not that interested. I'm not that interested. So it's not for your response, Mr. Nova, with all due respect. It really is me airing out what have been, I think, days of concern, and I am shocked by the method in which this has been covered, including a very deceptive and untrue headline in today's paper, which claims that we have paid over $300,000 in private investigators, which is not true. The actual number is $80,000 in 2011. And I believe that these things ought to be reported, and they ought to be reported truthfully and fully, and not with a bend or an eye towards some sort of conspiracy here that we have an interest in Mr. Jackson beyond what is appropriate. I have none whatsoever, and I wish that we can resolve this particular matter as soon as possible.
You know, our responsibility is to treat it. Go right ahead. Our responsibility is to treat every citizen equally and treat them the same way. And notwithstanding Mr. Jackson's statement, he has been treated that way. No better, no less than any citizen in this community. And I'll say that unequivocally. And it's difficult for me, of course, to sit up here week after week and hear somebody make false and inaccurate statements about me and my family. Without any substantiation. It's very difficult. But I've been trying to be silent, and I will. I will only say this, that he has a right to free speech. I will protect his right for free speech anytime, all the time. But he does not have a right under the Constitution to be believed in anything that he says. And I think Commissioner Gillum has outlined more with regards to this than needs to be stated at this point. And I will stop.